Awesome. Thanks, Nick. Well, welcome everybody. Happy New Year. And thank you for joining today. Sorry about the technical difficulties. So if anybody joined late, I can't go on video because it's causing some issues, but we managed to get around now. So let's get started. So lots to talk about today. I'm going to be going over what the difference between data privacy and data security, talk a little bit about why data privacy matters. I'm going to quickly review some data privacy laws and acts and go over a timeline, talk about data privacy risks, and then I'm going to get into the key elements of an effective privacy strategy and plan, and then talk a little bit about how you go about implementing those key elements, and then conclude with a few data privacy trends for this year. Hard to believe it's 2022. All right, so just to kind of level set a little bit in the beginning, I want to talk about the difference between data privacy and data security because there is a difference. These terms are often used interchangeably, but they are in fact different. I think one of the biggest misconceptions is that organizations commonly believe that keeping sensitive data secure from nefarious actors means that they're automatically compliant with data privacy regulations, when in fact that's really not the case. So one important point that I want to make here is that security controls can be met without also satisfying privacy considerations, but conversely, privacy cannot be met without security controls. And you'll kind of understand this as I go through the presentation today. So what are the differences between these two terms? Basically, data security is primarily focused on preventing unauthorized access to data, and it's the process or the application for limiting that access. On the other hand, data privacy relates to how data should be handled based on its relative importance. So the focus for data privacy is in how to collect, process, share, archive, or delete data. Now, another thing I'd like to note is that there's 3 factors influencing data privacy, and those are consent, notice, and regulatory restriction. A lot of you are probably familiar with the terms consent and notice, but I'm just going to briefly describe what those are. So consent is when you receive the customer's permission to share their data with third parties or other entities outside of a data privacy agreement that's between a business and a client. Notice is letting the customers know about legal collection and storage of their personal data. And then regulatory restrictions, that's where you have to remain compliant with national or international regulations that can help protect businesses from fines and criminal charges and their customers' right to privacy. So kind of to sum this up a bit, security is the protection against unauthorized access, whereas privacy is using data responsibly in accordance with applicable laws and regulations. Now, another thing to note is that data privacy goes beyond the personally identifiable information of its employees and customers for organization. It also includes the information that helps the company operate, whether it's proprietary research, development data, financial information. So it's beyond the PII. It's all inclusive. So let's talk a little bit about why data privacy matters. So nowadays, just about every business type uses some form of data for its operation. In fact, data is now the most valuable resource in the world ahead of oil. So pretty much businesses can't operate without data nowadays, especially in the digital world. Secondly, customers are becoming more concerned with data collection. They're becoming more aware of those rights. So it sort of creates a potential downside to collecting data, but it's good that customers are aware, and if you can keep your data safe, it builds the trust with your customers. So we're going to talk about all this in more detail. Laws I'm going to get into in a few minutes in some more detail as well, but laws are becoming a lot more comprehensive, and they're designed to provide that level of legal protection that customers and consumers are beginning to become more aware of that were not previously available. The regulatory landscape is continuing to grow, which I'm going to show you that in a minute with the graphic. And then lastly, because of the growth in regulatory regulations and frameworks and things of that nature, and because of the growth in the awareness by consumers, there's becoming more penalties and fines being imposed on businesses where there is a data breach or loss of data. There's litigation expenses that could be incurred, and obviously an organization's reputation is at stake should any of their consumers' data be lost or stolen. So this is a kind of a snapshot of some data privacy laws and acts. As you can see, it started way back in 1974, which wasn't that long ago, but it feels like it is. So that was the U.S. Privacy Act of 1974. And then there's been certain frameworks that have come about since then. Some of these that you see on the screen are frameworks, and some are actually regulations. So you can kind of see how these have kind of moved on over the years. They've become a lot more prevalent. It wasn't really until about 2018 that a specific privacy law came out. So I'm sure many of you are familiar with the GDPR, which is the General Data Privacy Regulation for the protection of European citizens' data. Since that time, a lot of the states have started to come out with their own privacy laws, and I'm going to cover those shortly. But you can kind of see how it's progressed over time. Now, these laws mentioned here are some of the more high-profile regulatory frameworks when it comes to data privacy, but you should also be aware that there are data privacy laws that apply to particular kinds of companies or for particular kinds of data, and HIPAA is a good example of that. So good, bad, or indifferent, lawmakers have recognized the importance of having data privacy regulation and the need to hold companies responsible for end-user data. That said, companies are now required to determine what data privacy acts and laws affect their users. So for instance, you must know where the data originated, whether it's a country or state, what personally identifiable information it might contain, and also how it's being used. So this is an interesting graphic I thought was worth sharing. This was developed by the IAPP, which is the International Association of Privacy Professionals. It's a really good website to bookmark and reference. This map represents privacy laws that have been passed or are in the works. So as you can kind of see from the color coding on here, California, Colorado, and Virginia all passed a privacy act, and these go into effect in 2023. This map was updated recently, a couple days ago, and the recent updates indicated that there's at least 15 state legislators considering consumer privacy legislation this year, with lawmakers in places like Arizona, Connecticut, Florida, and some other states that are going to be introducing bills. So as you can see from this graphic, more U.S. states are considering privacy laws, which will mean increased complexity on the compliance front for companies doing business in the United States. Now, enforcement of U.S. privacy law is currently dispersed across a wide number of government agencies. Many of the laws designate a specific enforcement agency. As of now, state attorney generals have a broad enforcement authority over privacy and security from a general basis, but their general authority is, over consumer protection. And the U.S. Department of Justice has criminal authority in particularly egregious situations. So something else to note here, you notice these are mentioning state privacy. Currently there's no federal privacy laws regulating many organizations. Each state has its own privacy laws, you can kind of see by this map. However, there's been a lot of press and a lot of articles that I've been reading talking about the need for a federal privacy law. So that will certainly be something to watch in the future. Another thing to note too is on this IAPP website, they have a U.S. federal privacy legislation tracker that may be worth looking at and following that too. So what IAPP does is they give you a couple ways to kind of slice and dice this information. So this first one is the graphic, you can see it visually. And then if you go into the website, there's another way to look at the state privacy legislation tracker. So as you can see from here, California, Colorado, and Virginia have all passed, that's by the red, right? So, and then there's all these other states that are looking to pass bills, or there's something in front of the Senate as we speak. And then it gives you kind of a graphic of what consumer rights are covered. I'm not going to go into the consumer rights right now because I am going to be covering those in a bit. But I just wanted to provide this to you as a good reference. to look at in the future. One last reference I wanted to bring to your attention is this website by Perkins Coie. This is a security breach notification chart. So this is another great resource that takes a deep dive into security breach notifications for each state. But before I go over this at a high level, I just wanted to state that the general definition for a privacy breach is that a privacy breach occurs when somebody accesses information without permission. Typically, a privacy breach will start with a security breach and it ends with the exposure or theft of data. So a privacy breach, although still a security incident that's targeting your personal information, is different from a data breach in that it specifically relates to your privacy rights, which is a legal matter. So even if no crime has yet to be committed with the sensitive data that may have gotten into the wrong hands, the fact that it was exposed becomes the privacy breach. So I just wanted to kind of level set that. So getting back to this notification chart. So what I did, and I'm going to bring it up on the next screen, but I selected 2 states for comparison. So I'm going to bring this up. I know the print is a little bit small, but what I did is I brought up the general laws for Rhode Island and the general law for the statute for Connecticut. Now, just looking at this quickly, you can see that what I wanted to show with this is that every state seems to have their own definition of what a security breach is, right? So you can see Rhode Island, they're saying unauthorized access or acquisition of unencrypted computerized data, whereas Connecticut is saying unauthorized access of electronic files, media, so on and so forth. And as you go down this listing, you can see even the difference in notification obligation, timing of notification is different by state, and it even gets different across some states as far as their definition of personal information, as you can see by this screen here. So great resource, just wanted to bring that to your attention. Definitely something to bookmark. All right, let's talk about some data privacy risks. So now that you have a little bit of background on terminology, some of the state laws and breach notification, let's talk about some of these, what some of the privacy risks are to collecting information. So it goes without saying that businesses have many data privacy risks when they collect, store, process any type of data, whether it's PII or proprietary. So the list you see here, although it's not inclusive, does represent some of the more common risks. The first one here, collecting and storing too much personal information. So to lessen data privacy risks, a business should only collect personal data that it truly needs and only store it if it needs it for future use. Now, the thing to remember here is that anything that is retained can be discoverable. And I'm going to talk a lot more about retention throughout this presentation. These next 3 here, insufficient procedures around access to data, insufficient processes for deleting data, and insufficient responses. I'm kind of going to group those together. So use or access of personal data should be restricted to those with a true need for data. So some of the privacy laws actually talk about whether somebody can view information. So it's not just whether you have access to it through a username and password. You know, if somebody is actually viewing it and they're not supposed to have viewing rights to it, that can be a violation of compliance. Some of the regulations are pretty rigid. Also, when procedures, if you have procedures that don't remove or anonymize all personal data when somebody leaves a company, that could expose the organization to compliance violations and potential fines too. Next up, we have lack of transparency regarding data collection and use. So this talks about a lot of the data privacy regulations often require very clear explanations of what personal data is, how it's collected, how the data is being used. So this information of how you're using it, how it's being collected, needs to be publicly available and easily attainable. So things like that usually reside in policy documents, such as a website privacy policy or a cookie policy. Now, just note that failure to have such policies and failure to respond to information requests in a timely manner will cause the company to fall out of compliance with the regulation. This next one, security measures, I don't think this is any big surprise to anybody, but again, as I stated before, it's virtually impossible to have privacy if you don't have security measures in place. So if organizations aren't keeping up with the ever-changing cyber risks and implementing proper controls, it's going to be very challenging to put the proper privacy controls in place. When we talk about using personal data for an unauthorized purpose, so this basically comes down to using the data for a different or hidden purpose, whether it's intentional or unintentional, would represent a compliance violation. So it's very important to understand how the data you're collecting is being used and for what purposes. And then this last one here, vulnerable applications, insufficient data security. So a lot of organizations have legacy applications or legacy systems that are web-facing or can be accessed externally that are kind of forgotten about, or there's a reason that the system can't be patched. So you want to also make sure that you're taking into account any of those legacy systems or applications, because those could absolutely be a very big risk for your company when it comes to data privacy. Okay, let's talk about the key elements of an effective strategy. So this chart is based on data privacy and data frameworks on some industry and international leading practices. I don't want you to focus on the numbers. There really is no order of importance. They're just kind of numbered for visual purposes. And I'm going to get into all of these in more detail. But I do want to state before I move on that there is not a one-size-fits-all approach for organizations. So I think hopefully you'll understand that as I go through some of these key elements. All right, so the first one, governance and accountability. So essentially there's three major things here when it comes to governance and accountability. There's board vision and strategy, we have scope, and then accountability. So when we talk about board vision and strategy, data protection and privacy is something that should be a regular topic that's discussed at a board level, given the global emergence of technology, as you saw the increased rate at which privacy laws are coming about, especially in the States, and additionally the global reach of customers. So I'll also add here that without that top-down support, it's really challenging to have a mature program in place, because if you don't have that top-down support, that message is going to be sent across the organization. When we talk about scope, this is where you have to understand what privacy laws are impacting the organization. So many organizations have offices, affiliates, or subsidiaries in multiple jurisdictions. So that being the case, those organizations tend to face a greater likelihood of various data privacy regulations impacting them. Now, to build a baseline to look at your scope, organizations need to focus on where personal data is likely to be stored, collected, or processed. And I'm going to talk about that in more detail in a minute. When we talk about accountability, so depending on the size of your organization, many organizations have data protection units, or they have business areas who deem a certain person accountable. But I know with the GDPR, for example, it requires organizations to have a DPO, which is a data protection officer. So I believe a lot of the other state regulations, I haven't really read through them all, but many of them do require that somebody is designated as that point person for the privacy program, whether it's a chief privacy officer or a DPO. You definitely need somebody who's going to spearhead that whole initiative. It's also a good idea to have a data privacy governance committee. I know a lot of organizations have cybersecurity committees and things like that. So if you already have a cyber committee, it wouldn't hurt to add some elements for a data governance, a data privacy committee as well. And again, a governance committee sets the tone at the top, which is instrumental in the success of a privacy initiative. Next up, we have privacy. We have policies, procedures, and privacy notices. So all kidding aside with the comic, a lot of organizations have that tribal knowledge of what needs to be done as far as policies and procedures, and it may not be formally documented, but I can tell you with the privacy regulations that are out, this is an absolute must. Organizations really need to get better at documenting their policies and procedures. They need to be clear and detailed and should be circulated to related parties across the organization to ensure compliance. So I'll also add here that it's one thing to have policies and procedures, but organizations also need to ensure that they implement the controls mentioned in the policy. So if you have a policy or procedure drafted and you're listing all these controls that are in place, but those controls aren't implemented, you're going to fall out of compliance. And conversely, if you have controls in place, but you don't have the policies and procedures to support those controls, that will also impair your compliance. Now, when we talk about assessments and assurance, so just like with cybersecurity, self-assessments should be done for privacy as well. And these help you assess kind of your maturity level, helps you recognize gaps in your program, and helps you improve your privacy posture. Privacy monitoring is also another important thing to be concerned with. These should be created and also documented. So I think you kind of understand the key terms here. These things need to be documented, very important for proving that you're compliant. But these need to be documented, and what monitoring does, it helps organizations identify gaps, and it helps to ensure that there's ongoing effectiveness in your program. Now, when we talk about data protection clauses, these help ensure that the risk of an engagement or process is properly covered through the appropriate clauses that cover any engagement with processors or sharing data with third parties for the purposes of conducting essential business. So a lot of organizations use third parties now. You probably have NDAs in place or contracts. The same holds true for privacy. Retention schedules, as I promised, this is going to be mentioned several times throughout the presentation. So retention standards should also be documented to ensure that all personal data are retained for only as long as necessary, taking into consideration the applicable regulatory requirements. Again, it's important to not only have the retention schedules in place, but they also must be followed, and that's going to have to be proven during an assessment or an audit. And then lastly, we have privacy notices. So the organization's privacy notice is typically posted on its website, and it should accurately reflect how an organization collects and uses data. I'm sure a lot of you have seen these on websites you may visit. But that being said, the privacy notices should be clear and easy to understand and also not contain any jargon. So a lot of organizations will collaborate with legal or outside counsel to ensure that the privacy notices meet legal requirements. And again, you want to make sure that you're compliant with your state regulations as well. Okay, back on the initial slide when I showed you all of the elements to a data strategy, I said there's really no priority order. If I had to pick a priority order, I would probably say governance and data mapping are neck and neck for number one, most important when you're developing a strategy. So data mapping is really important. Some of you probably do this for cybersecurity, but for privacy, it's really, really important to do data mapping. And like I said, to have that understanding of all of your data processing activities. And this also supports determination for a lawful basis. So there's a lot of benefits of data mapping. One is security. So that's obviously understanding where personal data is located and flowing throughout the business. It's the first step in understanding your risks that allow you to implement those proper security safeguards and then put the right controls in place. Another benefit of data mapping is that which has to do with data subject requests. So as part of data subject rights, customers may ask what data your organization is collecting, where it's being sent, having a record of processing those activities. And all of these makes it easier to respond in a timely manner, because as you saw with the comparison for just Rhode Island and Connecticut that I brought up a few slides ago, every state has their own reporting requirements. So if you have all of that information in a central location, it makes it a lot easier to comply with those regulations. And then a third benefit of data mapping is data breach response. So having a central data register helps the organization respond more appropriately to a breach and understand what data may have been exposed based on areas impacted by that breach. So that was a lot. The next thing, after you have your data mapping completed, you need to conduct a privacy impact assessment. So you'll see this when you start dealing with privacy. It's called a PIA. So this essentially is a tool for identifying and assessing privacy risks throughout the development lifecycle of your privacy program. So privacy impact assessment states what personally identifiable information is collected. It explains how that information is maintained, how it will be protected, and how it will be shared. So basically, a PIA is your due diligence in complying with privacy regulations. All right, security, I know we've talked about this quite a bit so far, but it's a key element in implementing a data privacy strategy. So you need to make sure that you have the proper controls in place to protect against unauthorized access. And a good framework that can be followed is the NIST CSF, or the NIST Cybersecurity Framework, which provides standards and guidelines. Now, some of you might be familiar with this from a, excuse me, a cybersecurity perspective, but NIST did incorporate privacy controls into the NIST CSF, so it's all inclusive now, cyber and privacy. But the basic premise is, whether it's cybersecurity or privacy or both of them combined, there's 5 pillars that they kind of adhere to that help you implement your programs effectively. And those are identify, protect, detect, respond, and recover. And within those, there's multiple subcategories, but definitely a good reference for you to take a look at. And again, I can't state this enough today, privacy is virtually impossible to address without first employing effective security practices. All right, data subject rights. I mentioned this a few slides back, but now I want to kind of get into the detail of this. So a big thing with privacy is it talks about data subject rights. So some examples of key rights are what you see on the screen here. I'm going to explain these. But before I do that, by definition, a data subject refers to any individual person who can be identified either directly or indirectly via an identifier such as a name, an ID number, a biometric qualifier, cultural, or social identities. So a whole lot goes into what kind of defines a data subject. Now, when we talk about right to information, that essentially is the ability of the data subject to ask the organization for information about what personal data is being processed and the rationale for processing that data. So when I start talking about all of these, keep in mind that organizations need to have a way to track these and document all of these things, and then prove that during compliance. So the next one is right to access, and this talks about allowing the data subject the ability to either see or view their own personal data, as well as to request copies of their personal data. Right to rectification is the ability to ask for modifications if a data subject believes their information is inaccurate. They have the right to ask the organization to rectify that information. The right to withdraw consent, that's the ability to withdraw a previously given consent for processing of the personal data. So that's another thing organizations you have to understand, based on the either international law that you're going to adhere to or the state law, whether you have to have that opt-in, opt-out clause and be able to track that as well. When we talk about right to object, this is referring to the right to object to decisions made solely on an automated basis. Now, what does that mean? An automated decision-making is any form of automated processing of personal data that produces a legal effect on or significantly affects the data subject. So this right provides the data subject with the ability to object to a decision based on automated processing. And using this right, the individual may ask their request to be reviewed manually because the person believes that the processing of, let's say, their loan, for example, may not consider their particularly unique situation. that one's a mouthful. That one's a lot to that one. The right to be forgotten, deleted, I'm sure everyone is vastly aware of this and has heard of this, but this is the ability of the data subject to ask for the deletion of their data. And this generally applies to situations where a customer relationship has ended. Now, with that one, it's important to note that this is not an absolute right. This depends on the organization's retention schedule in line with other applicable laws. And then lastly, we have the right for data portability. So this is where the data subject can ask for transfer of their personal data. And as part of that type of request, the data subject can ask for their data to be provided back to them. One thing I did want to say about the right to be forgotten and deleted as well. So when that request is sent to an organization, the organization has to make sure that it's the data subject's information is deleted from every system, backups, whatever the case may be. So just kind of keep that in mind too. Now, when establishing an internal policy on handling data subject requests, there's many things that organizations should consider. And some of those are things like how the organization intends to receive all of their requests. You know, what are the channels? Is it going to be a web portal? Is it going to be emails? You know, what are the channels that you're going to be receiving those requests? How are you going to be tracking those? Some other things to consider are what type of information is required from the data subject. Additionally, how are you going to ensure that requests are processed within that regulatory time frame? And what feedback would you have to provide to the individual if the organization is unable to fulfill the request within that time frame? Some other things are things like what's your documentation process for recording requests received and processed? How are you keeping track of all that information? And then, you know, like I've mentioned quite a bit today, what's your organizational retention policy for keeping records of requests received? So you're also going to hear, as you start working with privacy, you're going to hear these terms too, data controllers and processors. So there is a difference. A controller, as you can see on the screen here, they determine the purpose and the means of processing personal data. They appoint a processor. They make decisions about activities. And if there's a data breach, the controller has to report or notify supervisory authorities and the data subjects when a breach occurs. Now, conversely, a processor is essentially a third party, right? If you can look at it that way. So they process the data based on their contract with the controller. They are bound by the instructions that are given by the controller. They act on behalf of the controller. And in the event of a data breach, they have to notify the relevant controller impacted by the breach. So you can see most of the notification responsibility lies on the controller. Now, one additional requirement is that the data processor cannot use a fourth party to process any identifiable personal information without obtaining proper authorization from their client, which is essentially their controller. So that's an important point to keep in mind. So again, you're probably going to want to get legal involved if you start having this controller processor relationship. And then additionally, as to cybersecurity, if you're using any third-party vendors, controllers need to do their due diligence on their processor or third parties that they're using to help process their data. Another element is for the privacy strategy and program is data transfers and data sharing. So this is certainly where you want to get your DPO or CPO involved and legal. Understanding where your data is being transferred. If you're going cross-border, you need to determine if that's allowed. And if the other countries have certain laws that you need to abide by or whatever the case may be. So there's a lot when it comes to data transfers and data sharing. So again, this is instrumental. I talked about the data mapping and the privacy impact assessment. Those are instrumental in understanding where your data is being transferred, who it's being shared with, and what types of rules and regulations you need to adhere to. And again, these should be incorporated into your contractual clauses and agreements, especially if you're using processors to help you process, store, or transfer your data on behalf of your customers. Training and awareness. This is what, we get the eye roll from employees. It's like, oh, here we go again. What we're trying to get across here, though, is that training and awareness should not be a check the box activity, right? We don't want it saying, okay, we delivered our training and awareness, it's done for the year, check the box, now we're compliant. That's really not the case. It's really important to have this ongoing. And the challenge becomes that fine line between how much training is too much and how much is not enough. So trying to find that balance. I'm sure many of your organizations already have a cybersecurity awareness program in place because a lot of the cybersecurity regulations or frameworks require that. So if that's the case, you can simply just add on to that program and incorporate privacy into it. But having a strong privacy and data protection culture, that contributes towards a common goal. It makes your employees aware of what their responsibilities are. Everything, you should make them aware of all of your policies so that they know what's expected of them. It's certainly not a point in time activity, and it should be something that's ongoing throughout the year. All right, breach management. So when we talk about breach management, as we previously covered in each regulation, including the various states that I showed you kind of quickly, there are different breach notifications and definitions as to what defines a breach. So it's important to involve not only IT during a breach, but the CPO, the DPO, legal, and possibly even your cyber insurer. And one thing that I wanted to state too, I don't know if I already said this, but just like with a cybersecurity program, it's not just an IT issue, right? It's your people, your process, and your technology. The same holds true for a privacy strategy or program. It's not just IT or just legal. This is all inclusive. So it's your people, your process, and your technology that play into this. So when we talk about breach management, obviously we know cyber breaches can occur due to many reasons, and the same with personal data breaches. They can occur with malicious activity, human error, insider threat, things like that. So it's really important that organizations develop and implement a breach management process to quickly address breach incidents. The other important thing is to remember to test your plans. A lot of organizations will have incident response plans developed and documented, but they never test them. And you really don't want to be testing those during a breach. So by testing them, it ensures that everyone is aware of their roles and responsibilities. And it also helps the organization identify any gaps and make improvements before you are in the middle of a crisis situation. The last thing you want to do is try to make improvements or identify gaps during a crisis situation. So I would suggest considering engaging a third party to help you conduct incident response table exercises. CMPASS does perform that activity for organizations, and it usually fares pretty well because having that second eye kind of take a look at your processes and policies, we can help you identify those gaps and improve your incident response planning. And as you saw from the state comparison that I had, different states have different timelines as far as reporting breaches. So a lot of them are they're starting to lessen the time for breach notification. So during the middle of a crisis, the last thing you want to be worried about is having something go sideways with your incident response or your breach management. So definitely something you need to be aware of and make sure you work on that and it's solid. Another element, ongoing monitoring and validation. So 4 key elements here. So independent audits. These help organizations reinforce your privacy culture, whether you're doing self-assessments or you bring on a qualified third party to help do those assessments for you and identify those gaps. This is what I was talking about before, to have that sustainability, to keep the ongoing monitoring, to identify those gaps and continually improve your posture, whether it's a cybersecurity assessment or a privacy assessment. You want to make sure you're constantly improving and updating, especially given the fact that data for organizations is more of a dynamic thing. Organizations are constantly changing with the intake and output of data. Security is, I don't want to say it's static, but it's more static than privacy. So it's certainly important to have those independent audits done. You also want to develop KPIs and KRIs. So these help ensure that privacy, your culture, and your program is not only measurable, but it's enforceable. So some of the KRIs or KPIs, you can include things like number of data breaches, the number of PIAs completed, any privacy issues that were escalated by staff or whomever that may be, kind of keeping track of privacy issues, whether they resolve, the time to resolve, privacy training completion rates, and you can even track things like results of mock breach exercises. So those are all good key KPIs and KRIs. Next, benchmarking against best practices. So we've talked a bit about implementing a framework. So whether you have a program in place or you're just starting, it's always good to benchmark against a best practice because they provide for the best practices across many industry verticals and organizations. Now, as you can see from the screen here, the benchmarking against best practices, this should be formalized in the DPO job description. So again, you can kind of see the theme here. It's really important to identify somebody who can oversee your privacy program and practice and have that accountability. And again, record retention, right? We've talked about this numerous times today, but I can't stress the importance of that. So you want to make sure that you have a record retention policy in place and that it's being followed. Okay, privacy frameworks. So cybersecurity and privacy frameworks provide methods, processes, best practices that can help organizations achieve better compliance with various security standards and data privacy laws. But there is a difference. So what's the difference between a security framework and a privacy framework? Well, essentially, cybersecurity frameworks help reduce risks associated with the loss of confidentiality, integrity, or availability. It's a CIA triad. Whereas privacy frameworks help reduce risks associated with unintended consequences of data processing. So there is a difference. And again, some of them, like the NIST, I listed the NIST privacy framework on here because NIST did come out with a framework for just privacy, but they also did incorporate that into the NIST CSF framework. For organizations looking to comply with GDPR, I mean, even though there's the law here itself, if you're looking for a framework to be compliant with that, the ISO 27701 is a good place to start, and that will help you achieve GDPR compliance. But this is a small list of many of the frameworks that are out there. I like NIST, and like I said, the IAPP website has some really good information, as well as ISACA. So, you know, at this time, there's obviously a number of well-regarded and adopted cybersecurity and data privacy standards on the market. And I think as more state regulations are presented and possibly even a federal legislation that's being talked about comes about, you're going to start seeing frameworks change to help organizations implement those regulations and meet those compliance regulations. Anything else I wanted to say here now? Okay. All right, so how do we put all of those key elements together to implement a privacy program? I know I just gave you a lot of information in a short amount of time, but hopefully this slide kind of sums it up for you. We've talked about pretty much all of these, but I just wanted to kind of summarize it here in one screen. So as I mentioned before, the challenge with privacy compliance is that business is dynamic, meaning that it changes daily and personal data is pervasive across the entire organization, whereas security for the most part is somewhat static. But as organizations are constantly getting data in and out and storing it and processing it and transferring it, there's a lot to understanding data privacy. So privacy compliance is more about managing risk across the full life cycle of data, from, like I said before, from inception to deletion, and even storage. So it's understanding all of that and everything in between. So in order to effectively do that, like I mentioned before, you want to make sure you appoint somebody in your organization. Before a lot of these state laws came out, aside from GDPR, not many of the regulations really required the appointment of somebody designated to oversee a privacy program, but it's becoming much more relevant, especially with all of these state laws coming out. So you want to make sure you have somebody qualified to oversee that. And again, that shows the support from the top down. You want to identify privacy drivers, and that's where organizations should have a clear understanding of the state or international privacy compliance regulations and the risk to personal information within your dynamic environment. Documenting data process flows and PIAs. Again, I can't stress these enough. I think that is, if you have to start somewhere in your organization, if you're just starting off with a privacy program, that is definitely the place to start after you appoint somebody to oversee this. But you really need to understand where your data is, who's using it, who has access to it. You want to make sure that you document everything that I showed you as far as data subject rights, so that if a data subject comes back to your organization and says, you know, I need you to change something because it's inaccurate, I need you to delete my data, I need to view my data, whatever the case may be, you want to make sure that you're able to provide that information in a timely manner to the consumers, because as I stated, consumers are becoming a lot more aware of what their rights are. Use a privacy framework to establish the program. So again, we just talked about that. That can help you kind of get off the ground, can give you a baseline from where to start. And those aren't, I want to say those are prescriptive. Some of the things that you see in those frameworks may not apply to your organization, and that's fine. You want to kind of make sure you customize it to meet your needs of your industry vertical. You also want to make sure that you define, communicate, and document your privacy policies, right? We talked about this in some pretty good detail. So having those privacy policies documented and making sure that the controls that you mentioned or the items that you mentioned that you're doing in those policies are being adhered to and that they are implemented. And conversely, if you make changes to any of the controls for security or privacy, you want to make sure that you update your policies to match the controls, because all of that will be checked during an audit. Developing and implementing the plan, obviously those are steps that you take all of these and put it into action. Now, one thing I want to say there is, you know, it's not, once you implement your plan, it's not just, you don't just kind of leave it there and kind of let it run on its own, right? It's like cybersecurity. You want to make sure it's considered business as usual. And again, it's not an IT, it's not solely an IT issue. It's your people, your process, and your technology. And with privacy, you want to ensure that the proper business areas are also involved in these processes, because a lot of your business areas are doing a lot of the processing or storage of information or accessing. Also, as part of the implementation plan, you want to make sure that you implement monitoring controls and use of personal information. So ongoing monitoring of the environment is very critical to ensure that controls are in place and protecting the personal information in the environment. So that really requires that the organization has insight into where personal data is stored and used. You want to be able to monitor it for leakage or inappropriate use. And that also, you want to make sure you have full audit trails of interactions with your personal data. Governing third-party relationships, we've talked about, so that's the relationship between the controller and the processor. You want to make sure that you have contracts or NDAs in place and make sure that the processors understand what their roles and responsibilities are. Obviously, incident response is a big one too. Like I said, a lot of organizations probably have a cybersecurity incident response plan in place, but you want to make sure that you're also including your privacy response to potential breaches, and make sure you're testing those plans as well. Now, when we talk about developing sustainability, that is keeping the privacy management program momentum going, right? So you want to review the overall success of the initiative, identify further privacy requirements for the organization, reinforce the need for continual improvement. And that's a lot of times where those assessments and assurance come in. You identify the gaps and make sure that your program is moving forward the way you want it to, and in line with all of the regulations. So once all of these are in place, the next challenge is to keep it current. So to that, I'll just say that you may want to consider automation where it's feasible and, you know, economical for your organization, because doing all of this manually with documents, spreadsheets, things of that nature will most likely lead to gaps and errors, and eventually possibly cause significant issues of non-compliance, resulting in potential penalties. And a lot of that has to do with the documentation around data subject rights, being able to quickly get that information, make changes, provide that information to the data subject. And a lot of the regulations are requiring organizations to have documented policies, documented risk assessments, and so on. We're doing a time. Okay, so some of the trends for 2022 that I've been kind of seeing, I don't think any of these should come as a big shock to anybody. You know, as I mentioned before, consumers are becoming more aware of their rights and the value of the data they share. So when a privacy breach occurs, regulators are more likely to impose fines because of the fact that people have become more savvy on their rights to data. You know, and today you can pull up on any website, you can just Google it for that matter. You know, customers are not looking away when it comes to how their data is being used and the type of data that's being collected, and they're starting to understand their rights more as well. And because of that, because of the customer's awareness, organizations are being imposed some stricter fines because of that, because people are speaking out. Obviously, there's going to be more education and training, especially as some of these state laws come about. There's going to be possibly new privacy standards. I talked a little bit about a potential federal regulation coming out. Again, this next one here, the rise in number of data subject requests and complaints, that's because of the fact, kind of circles back to the fact that customers are becoming more aware of their rights when it comes to their data privacy. Third-party risk management, I think we've all seen this in cybersecurity, the number of third parties that have been hacked or whatever and used as the pivot point to get to other organizations. So you want to make sure you're doing your third-party due diligence, making sure you're vetting your processors, making sure you're having solid contracts in place. I think in 2022, we're going to see a shift from a nice to add to a must have when it comes to privacy. And this is because customer attitudes towards transparency and data protection are gradually evolving, and companies are being compelled to create more awareness on these issues. And really what it comes down to is providing that trust for your customers or your clients, right? You can't build a trust if you have a breach in your company. You're going to lose trust, you're going to lose reputation. But if customers can trust you that you're going to protect their data, that will go a long way. So I think moving forward, transparency is going to become very important for all organizations, no matter what your industry vertical is. And again, transparency is providing those clear explanations of what personal data is collected and how the personal data is being used. Like I mentioned before, whether it's intentional or unintentional, you really need to make sure you have a solid understanding of what data you're collecting, how it's being used, and making sure that you are relaying that information in a clear and concise manner. All right, so to wrap this up, hopefully we all understand that data privacy is very critical to the survival of modern day business. I think it's become increasingly important in understanding where information may be stored. It could be stored in many locations nowadays, whether it's cloud or whatever the case, but I think the pandemic has definitely increased that footprint with the major shift to work from home. So it's becoming really, really important to understand what types of data you're storing, where it's being stored, who has access to it, all of those types of things. So privacy isn't simply a must-do mandate, but it's an important part of your business strategy that can really help do a lot to boost your brand and your bottom line. Again, it goes back to that whole trust factor and your reputation. At the end of the day, you want your clients and your customers to trust that you will protect their data. The other thing that I'll say is that privacy and data protection compliance is a journey, right? It's something that you have to keep doing and improving on, just because of the dynamic nature of the way in which businesses collect data, the way in which regulations are constantly changing. also the privacy risk management as a practice, that's across disciplinary function too. Like I said before, it's not just an IT problem, it's not just a legal problem, it's all of your people, process, and technologies. It requires support and engagement from stakeholders across the organization. You want to make sure you have that top-down support. You know, and the thing is too, with privacy regulations being enacted, I think organizations are going to begin to face more scrutiny and more potential for regulatory fines. I mean, like I said, you can Google privacy breaches now, and there's just numerous cases where fines are being imposed on organizations, and a lot of this came about because of California's really strict laws. They seem to be the leader in most regulations, and other states seem to follow, but you want to familiarize yourself with the states that are applicable to your organization. So, you know, at the end of the day, no matter what size your business is or how mature your compliance program is or how many people you have on your compliance team, most businesses do have room for improvement when it comes to data privacy. So I would recommend that you take some time sooner rather than later to evaluate your company's data privacy policies and practices. Make sure you have those documented. And then I will just wrap up with saying that I know I presented quite a bit of information today, and this may seem overwhelming, but whether you're implementing a cyber security or a data privacy program for the first time, or even if you have a program in place, it's always a good idea to seek help from qualified organizations such as CMPASS, and we can help you ensure that you have the proper elements implemented. So that, I will turn it over to Nick, and I want to say thank you very much, everybody, for attending today. I hope this was valuable.